Can you see me, ma'am? Okay, I can't. Who are you? I can't hear. I don't
Okay,
know.
I'm sorry about that. I'm Angelica Correa's mother.
Okay, is there any reason why we should be seeing each other? I'm Daphne Smalls. I'm trying to get to a
Haven't
courtroom.
started yet. Just turn your cameras off and leave your mics on mute, please.
How do I turn my camera off?
All right, good afternoon, everyone. Let's go ahead and get started. This is the state expedited accusations calendar in the state court of Fulton County, Georgia. I am Judge Melanie Williams, and today is June the 6th of 2025. All defendants, please be advised, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel at this proceeding today. As you can see, I am conducting this hearing by video. I am not in person with you. It's also being broadcast over the internet as a live stream, and it's being recorded. That means any member of the public can log on and watch this particular proceeding. When I ask if you understand your rights, I'm referring to those rights that I just explained and how I'm conducting the hearing today. Those who receive a signature bond will be reset those who receive a signature bond will be reset for the notice. Those who receive surety or cash bonds today are going to our state all-purpose calendar, whereby certain aspects of the case can be revisited. That date is June the 19th. Have all defense attorneys had the opportunity to interview their clients?
With the exception of number 20, Your Honor, I'll need a breakout to explain why.
Okay. All right, we'll do that towards the end. Thank you, Mr. McLean. Can we take Ms. McLeod's client first? Is that possible?
We can, Judge.
Afternoon, Your Honor. I have three.
All right, can we take those three if possible?
We can go to position 4, Judge. Ms. Carrera.
Okay, Ms. Correa, your case is 25 CR 003186B. In this case, you are charged with battery, family violence, simple battery, family violence, and simple assault, family violence. Do you understand your rights this afternoon? Is that a yes? I need you to say that very loudly for me.
I apologize. Yes, ma'am.
All right, thank you so much. Mr. Howard? Oh, first the rest, so we'll go to Ms. Falk.
Yes, Your Honor. This happened June 5th, 2025 at around 12:15 a.m. at 221 Lampkin Street. The issue was that Matthew Baker stated that he and the defendant, his wife, got into an argument about money. And during the verbal argument, the defendant began throwing multiple items at him, including a bowl of yogurt. The argument then continued. The defendant grabbed her purse, which contained a glass jar inside, and struck Mr. Baker in the face with it. Officers did observe a laceration to the face of Mr. Baker, and when they questioned him, Mr. Baker stated that they had tried to treat the wound at home and were unsuccessful, which is when he called 911 to report the assault and for medical assistance. The defendant did admit to grabbing the purse and hitting Mr. Baker out of frustration due to the argument about money. We did have an opportunity to speak with Mr. Baker. He stated
Mr. Baker, do you mind just sitting down? Mr. Baker, is that you at the screen that says Mike? Okay, can you please?
I don't believe so. Our
maybe
victim's
not.
name is.
Sir, whoever you are, please sit down or turn off your camera until we're speaking with you. It's quite disturbing. Thank you. I'm sorry, Ms. Falk. Please continue.
Thank you, Your Honor. We talked to Mr. Matthew Baker. He stated he and the defendant are married. They live together, but they don't share any children. He did confirm the events in the warrant. He also stated this isn't the first time the defendant has been violent towards him, but this is the first time the police have been called out. He said he is in fear of the defendant. He does not want any contact. He would like for the defendant to stay away from the residence. He will also need a one-time law enforcement. The defendant will
Ms. Falk? I think we lost Ms. Falk.
I will check in and see what's going on. Good afternoon, Your Honor.
Good afternoon, Mr. Sirocco. I think that Ms. Falk is frozen. All right, Ms. Falk, are you back?
Yes, my apologies. Let me try to get to a better location. I apologize. So the bond recommendation is 5,000 surety, 3,000 on the battery, 1,000 on the other two remaining charges of simple battery family violence and simple assault family violence. No further contact with Matthew Baker. Stay away from 221 Lampkin Street. Family violence intervention program and no alcohol, drugs, or weapons to include no firearms. At this time, we would like to sound for Mr. Matthew Baker. That's all for the state.
All right, is Mr. Baker present? Hearing none, Ms. McLeod, I'm inclined to give your client a signature bond at level 1, require the anger awareness course, but I am gonna restrict her from her home at this time based upon the representations given to me by the state. Do you have any objections to that, Ms. McLeod? If so, please feel free to lodge those at this time.
I do not have an objection to the signature bond, Your Honor. My client would need a one-time police officer escort back to the location so that she can get her belongings, since the court has decided there should be no further contact. My client has given me a separate address which she plans to be, so that is not going to be an issue, Your Honor.
Defendant is gonna receive a $4,000 signature bond at level 1, broken down 2,000, count 1, and 1,000 on each of the remaining counts with a total of 4. She's to have no contact with the alleged victim in this case. Stay away from that location. She can return one time with a member of law enforcement to get any items. Additionally, she's to have no alcohol, drugs, weapons, and will be reset for the notice. Is there anything
will she-
additional?
Yes, Your Honor. I just want to make sure she will be able to report via telephone because she plans to move to the state of Florida.
I don't know if that's possible. Mr. Howard, is it possible?
Uh, depends on what you rule.
Okay. When does she plan to move to Florida? She's at level 1. She
Now,
does
she's
check in.
planning to move back with her mother, Your Honor, who lives in Florida. My client has no history whatsoever. She's 31 years old. She plans to go back to college to finish up. I think most of the issues is with the other party,
Okay,
quite
she can
frankly.
report by phone. That's fine. All right. Anything additional?
Nothing further, Your Honor.
All right.
Nothing
Thank
from the
you.
state.
All right. Best of luck to you, ma'am. Who do we have next?
Position 13, Mr. Clinton.
This is Natasha McClendon.
Yes, Judge.
All right, Ms. McClendon, your case is 25 CR 003200J. In this case, you are charged with simple battery, family violence, 2 counts, obstruction, and simple battery against an officer. Do you understand your rights this afternoon? All right, thank you, Mr.
She got
Howard.
6 total on probation for ag assault, ag battery. Had a 2024 ag assault, 2 counts, battery. That was DWOP, and a 2024 battery DV conviction.
Okay, thank you. Mr. Nixon, please proceed.
Yes, Your Honor. This occurred on June 5th, 2025. Officer Ash was dispatched to 2950 Springdale Road, Southwest Apartment A6. When the officer arrived at the location, the officer heard screaming from the apartment, then knocked at the door, and a child opened it. And the officer then saw 2 females fighting each other on the ground. Shortly after, both females were separated. The female that was on top was identified as the victim, Tamika McFadden, and the female at the bottom was the caller, the defendant. Ms. McFadden stated that they were not related or in a relationship. They were just 2 roommates for around 4 months. And the victim stated that she was sleeping at the location, and then Ms. McClendon, the defendant, woke her up. Ms. McFadden stated that she and the defendant were having a verbal altercation regarding an EBT card. An altercation ensued, and while fighting, the victim stated that the defendant bit her left breast and was pulling her hair. Ms. McFadden, let's see, the defendant was on top of the victim and pulled her hair. McClendon was intoxicated, and the officer noted that there was a clump of the defendant's hair on the ground, and there were 2 clumps of the victim's hair on the ground. The defendant was determined to be the primary aggressor. The state is going to ask for $1,500 surety for the simple battery, $500 surety for the obstruction, $1,500 surety for the simple battery, family violence, $1,500 surety for the simple battery against a law enforcement officer, a stay away from that was 2950 Springdale Road, apartment A6, alcohol, drugs, evaluation treatment, no alcohol, drugs, or weapons while out on bond. And the state would ask that the court sound for the victim when appropriate.
All right, is Ms. McFadden present, wishes to make a statement?
My client's Miss McFadden, Your Honor.
Okay. Okay, I'm sorry, what was the name of the victim then? Mr. Nixon?
Name of the victim is Tamika McFadden.
Yeah, your client is Ms. McClinton, isn't that correct, Ms. McLeod?
Yes, Your Honor.
Okay, so I'm sounding for Ms. McFadden.
Okay.
Okay, hearing none, Ms. McLeod, please proceed.
Yes, Your Honor. I would ask for a signature bond for my client. I believe the warrant says that my client was the one who called the police, that the alleged victim was on top of my client. My client had injuries. It's a puzzle to me why, at the very least, they were not both arrested. To suggest that the police officer determined that my client was the aggressor when he came and he found the other person on top of my client seems a little bit odd to me. My client tells me that she was attacked by Miss McFadden after she had asked her for the card. The EBT card belonged to my client. And when she indicated to Miss McFadden that she wanted her EBT card, then that was when she was attacked and she called the police officers for help. And then she ends up being arrested, even though they saw the alleged victim on top of her. It's a mystery to me, Your Honor. So I would ask for a signature bond for my client so she can get out of jail. She's not in a position to pay for bond, Your Honor. And I don't believe she has any significant history based on what I heard. They say she had an arrest which was dismissed. I don't believe she has any FTAs or any open cases. Nothing further, Your Honor.
All right, defendant is going to receive a $2,000 surety bond, 500 on each count. She's to have no contact with the alleged victim. She's to stay away from that location. Should she need to return one time, she can do so with a member of law enforcement. Additionally, she's to have no drugs, no alcohol, no weapons as a condition. Is there anything additional? All right,
No,
hearing
Your Honor.
best of luck to you, Ms. McClendon. That concludes your case. Who do we have next?
Position 18, Mr. Stewart.
All right, Mr. Stewart, good afternoon. Your case is 25 CR 003199B. You're charged with 2 counts of simple battery family violence. Do you understand your rights today? Is that a yes? All right, thank you. Mr. Howard?
2014 probation, 2013 ag battery, family violence, 2010 ag assault, ag battery, terrorist threats conviction, 03 simple assault trespass conviction.
Thank you. Mr. Sirocco?
Thank you, Judge. This incident took place February 16th, 2025 at 3071 Middleton Road Northwest in Atlanta. That is an apartment complex. Law enforcement responded to a family violence dispute call. Upon arrival, the officer made contact with the victim, in this case, Ms. Shante Brame, Brame, who explained that the defendant, her ex-boyfriend, who shares a child with her, came to her apartment and questioned why her cousin was there. They got into a verbal altercation after the cousin left, and that altercation escalated to become physical. The victim was seated on a chair in the living room. Defendant grabbed her by her clothes and pushed her against the wall, causing her head to hit the wall, then pushed her down the hallway into the bathroom, pinning her inside while their 4 children were in the adjacent bedroom. After the victim's cousin returned and got the defendant off of her, the defendant punched several holes in the hallway walls and grabbed the victim's phone and threw it, causing it to break before leaving the apartment. She identified the defendant through a photograph, the DDS photo, when his information was run, and a warrant was issued for his arrest. We have spoken with the victim here. That she confirmed they're in a relationship and live together at the incident location, sharing 1 child. She confirmed the events in the police report, stated that this hasn't happened before and that they have been living together since the incident without issue. And she's not in fear of him, wants to continue contact. However, we are not okay with that. We're concerned for her, especially given his history here. The aggravated battery, terroristic threats and acts, ag assault from 2010 that pretrial mentioned, the ag battery, family violence. Both of those are family violence, by the way. The one in 2013 was against his wife, Lauren Stewart, where he threw hot grease on her. So those are serious convictions, serious violent convictions, and we're concerned for this victim's safety. While I don't believe she's on the line, we would ask that the court sound for her at this time. We would ask for a $7,000 surety total, $3,000 for each simple battery family violence, $500 for each criminal trespass, for him to complete FFIP, have no further contact with Shantae Brame, stay away from the apartment complex located at 3071 Middleton Road, Northwest in Atlanta, and no drugs, weapons, or alcohol while out on bond.
Okay, is Ms. Brain present and wishes to make a statement? Hearing none, Ms. McLeod?
Yes, Your Honor. The state has mentioned some incidents in my client's past. These were all well over 10 to 15 years ago, Your Honor. My client is gainfully employed. He tells me that he has been employed and working at this particular job that he's very anxious to get back to. He does have 2 minor children that he's supporting. One is 17 years old. The other one is 2 years old that he shares with the alleged victim. He tells me that both Miss Brain and himself were surprised that he was arrested because they just had a disagreement. I noticed that there's nothing in the warrant that says that she had any visible injuries on her or anything like that, Your Honor. This was just a situation where she was making allegations, uncorroborated allegations, I might state, to the police officer that something has happened. And she has told the state and that they're still in a relationship, they're still living together. This incident apparently happened in February, this months ago, Your Honor, so there is no reason why they cannot continue to have contact, given that they share a 2-year-old. So I'm asking for signature bond for my client at whatever level the court deems appropriate, and that it be conditioned on no further violent contact with Ms. Brain. Nothing further, Your Honor.
Just
All right.
on, very briefly, Judge, just on the corroboration, the damage to her property, the walls and the phone were observed. I just want you to know that as well.
All right, defendant's gonna receive a $2,000 surety bond. He's to have no further violent contact with the alleged victim, have no alcohol, no drugs, no weapons, and because he's receiving a surety bond, he is going to all-purpose on the 19th. Is there anything additional?
Nothing further, Your Honor.
All right, best of luck to you, Mr. Stewart. Ms. McLeod, does that conclude your business today?
It does, Your Honor.
Take
Thank you. Have
care.
a good afternoon.
You too. Have a good
Thank
weekend.
you.
Bye-bye.
You too.
Got position 5, Ms. Dansley.
Okay, Ms. Stanley, your case is 25 CR 003187C. You're charged with obstruction and fair evasion. You understand your rights today?
Yes, ma'am.
All right, Mr. Howard.
27, probation, the cap for simple battery. 2025 felony obstruction, trespass, disorderly conduct. 2024 simple battery, 2024 simple battery obstruction. 2017 simple battery conviction, 16 battery DV conviction, 14 obstruction conviction, and a 2011 battery DV disorderly shoplifting conviction.
Okay, thank you. Ms. Fall?
Yes, Your Honor. This happened June 5th, 2025 at the Inman Park MARTA station at 1055 DeKalb Avenue Northeast in Atlanta. The defendant entered the fare gate without paying the $2.50 required fare. The officer stopped her. She became agitated, was unable to provide a valid breeze card, and when the officer went to take her into custody, she began actively resisting and fighting the officer. as you've heard, this defendant has 26 cycles. She actually was convicted of that simple battery out of DeKalb County in April 9th of 2025, which was less than 2 months ago. The felony obstruction arrest was in January of 2025, about 5 months ago. So it is still pending. That was a felony obstruction for fighting officers, criminal trespass, and disorderly conduct. She also has a December 2024 arrest for simple battery that was bound over to us from municipal court that is pending. And then you heard about the convictions for family violence battery, simple battery, family violence battery, and theft by shoplifting, and then a 2011 aggravated assault conviction in Gwinnett. The reason I'm telling you all this, Your Honor, is because I'm taking an unusual step. I usually on fair evasion of obstruction would ask for a signature bond. I'm asking for a $1,000 surety bond due to the fact she has a lengthy history of violence, especially of violence against officers. And in this case, she was fighting the officer. We're also asking for a stay away from all MARTA, no alcohol, drugs, or weapons. That's all for the state.
Is Ms. Tucker, is this your case?
Yes, Your Honor.
All right, please proceed.
We are requesting a signature bond on all counts for Ms. Dansby. She is 37 years of age. She is currently not employed due to a disability. She is an Atlanta native and she has 5 children, 2 of which are minors, who she is the primary caregiver for. She was at the MARTA because she does not have transportation at the moment. So she does use public transportation primarily as her mode of transportation around the city. So we would ask that she not be banned from all MARTA stations and request that she be granted a signature bond on both counts.
Defendant is going to receive a split bond. On the fair evasion, she's going to receive $1,000 SOB through the jail. On the obstruction, she's going to receive a $10 cash bond. So that's $1,010 total. She's got to make bond on the $10. She is to have no alcohol, drugs, weapons. I won't restrict her from MARTA at this time. However, if MARTA has instituted their own ban, she must comply with that. And she will be reset to all purpose on the 19th since I put the cash bond on there. All right, is there anything additional from State of Defense?
No, Your Honor.
All right,
Thank you.
best of luck to you, ma'am. That concludes your case. Who do we have next?
I got position 8, Ms. Harnett.
Okay, Ms. Hartnett, your case is 25 CR 003190Y. You're charged with battery, family violence, cruelty to children in the 3rd degree, and simple battery, family violence with the offense date of June the 5th. You understand your rights? All right, Mr. Howard.
5th arrest, 2019 DUI conviction, 15 battery DV, NOD, 14 cruelty to children, simple battery DV, dismissed.
Okay, thank you. Mr. Nixon?
Yes, Your Honor. This occurred on June 5th, 2025. Officers responded to a dispute call at 361 Oliver Street Northwest. A 911 caller advised a male and a female was fighting outside of the location. Now, upon arrival at the location, officer was stopped by the defendant, who advised she had called police and that she was assaulted at the location by her child's father, Mr. William Wallace, the actual victim. Now, the defendant advised that the dispute began when she came to the home to drop off their minor child, initials SH, and the defendant began arguing with Mr. Wallace. Officer then spoke with Mr. William Wallace, who advised the defendant came to the home acting irate, and she charged into the home, passed him into the home when he wouldn't allow her in. Now, Mr. Wallace advised the defendant began arguing with him and then began fighting him and pulling on his clothes, leaving his shirt and underwear torn, as well as scratches on his side and his back. The injuries were visible and they were photoed by the officers. The officer then spoke with Mr. Kevin Roos, who corroborated Mr. Wallace's statement that the defendant charged into the home and began attacking Mr. Wallace. Mr. Roos advised he began to record the incident. Roos showed the video to the officer, which showed Mr. Wallace attempting to restrain the defendant while the defendant appeared to be holding him and yelling expletives. The minor child, again, SH, was present during the assault. Now, our office was able to talk with the victim. The victim and the defendant are not in a relationship. They do not live together. They share one child. The victim stated that the incident location is his friend's residence that he was hanging out at, and the victim confirmed the events in the warrant. The victim stated that the index finger is injured and he cannot move it, as well as scratches and bruises on his body. The victim stated that it is not the first time the defendant has been violent towards him, but the first time the police has been called. And the victim stated that he does not want contact with the defendant, but they need contact because of the child. The victim stated that they do not have a third party that can transfer the child, but the victim wants the defendant to stay away from the incident location. The state would also ask that the court sound for the victim when appropriate. For these reasons, the natures of the charge, as well as some violent arrests between 2014, 2015, the state is going to ask for a $3,000 surety for the battery family violence, $1,000 surety for the cruelty to children in the third degree, $2,000 surety for the simple battery family violence, and that's going to be a total of $6,000 surety. The state would request no further contact with William Wallace, stay away from 361 Oliver Street, no alcohol, drugs, or weapons while out on bond, FBIP, the Family Violence Intervention Program, and again, sounding for Mr. William Wallace.
All right, is Mr. Wallace present and wishes to make a statement? Hearing none, Ms. Tucker?
Yes, we are requesting a signature bond on all counts on behalf of Ms. Hartnett. She's 33 years of age. She's an Atlanta native. She has maintained employment at Amazon as a data analyst for the last 8 years. She has 5 children who are all minors that she's the primary caregiver for. We have no objections to not returning to the incident location, as well as no contact with the alleged victim. However, we are requesting a signature bond. She has no prior failure to appears. She has ties to the community. And I'm seeing her last date of arrest prior to this incident was in 2019. So it has been years. I'm not seeing any reason to believe that she's likely to re-offend if she's released out on signature bond.
All right, defendant is gonna receive a $1,500 surety bond, $500 on each count. She's to have no further contact with the alleged victim in this case. Stay away from that incident location, have no alcohol, no drugs, no weapons, and she is going to all purpose on the 19th. Is there anything additional? All right, best of luck to you, ma'am. That concludes your case at this time. Who do we have next?
Position 12, Ms. Jones.
All right, Ms. Jones, good afternoon. Your case is 25 CR 0031988J. You're charged with trespass in this case. Do you understand your rights today? Is that a yes? All right, thank you. Mr. Howard?
30. On probation, ag assault. Well, 2 different ag assaults. 2025 trespass, 24 probation, 20 parole violation, 2011 simple battery conviction. She has a bench warrant. That's it.
Okay, thank you. Mr. Nixon?
Yes, Your Honor. This occurred on May 10th, 2025. Officer responded to a suspicious person call at 4875 Old National Highway. That's the Chevron Food Mart there at that location. And upon arriving, the officer spoke with the store clerk, who advised that a female was disturbing customers. Store clerk advised that the female had spit on the glass window. He also advised that the female had previously been given a criminal trespass warning from that particular location. Officer made contact with the female and recognized her as the defendant, Ms. Jones there, and the officer was able to identify her due to coming in contact with her on multiple occasions for criminal trespass, loitering, and disorderly conduct. Ms. Jones, the defendant, was then subsequently placed in custody. She received a criminal trespass warning from 4875 Old National Highway on February 5th, 2025. The defendant has you've heard the criminal history, Your Honor, multiple convictions and arrests, with the most recent, I believe, being the 2025 probation revocation, ag assault in 2023 and 2025. The state is going to recommend and request $1,500 surety for the criminal trespass, a stay away from the 4875 Old National Highway, alcohol, drug, and evaluation treatment, and no alcohol, drugs, or weapons while out on bond.
Thank you, Mr. McLean.
Thank you, Your Honor. Ms. Jones is 7 and has Roosevelt Highway address with apartment, so she's got stable address, high school education, works in restaurants, and we would ask the court to consider, given the nature of the charge, if an FTA is if a signature bond is legal, we would ask for that. If it's not, we'd ask for the $1,000 bond, which we believe is the lowest surety bond that a bonding company would put. Thank you.
All right, thank you. Defendant is going to receive $1,000 surety bond. She's to stay away from that location on Old National Highway, have no alcohol, no drugs, no weapons. Is there anything additional?
Nothing.
All right, best of luck to you, ma'am. That concludes your case. Who do we have next?
Position 1, Mr. Block.
I'm sorry, position 1 I have is Sundai Bailey. Is that who's coming? Or we have Ashanti Barber. Who's coming?
Position 3, Judge.
Position 3? Okay. This is Alto Blocker. Okay, my apologies. Your case number is 25CR003176Y. You're charged with theft by shoplifting and criminal trespass. You understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
80 plus. Most of them come out of Florida. 2024 trespass, possession of drug-related objects. 23 shoplifting. 23 probation. 22 trespass. 2017 grand theft conviction. 2015 possession of a controlled substance conviction. 2013 petty theft conviction. I stopped there.
Okay, thank you, Mr. Nixon.
Yes, Your Honor. The state. So this occurred on June 4th, 2025. The officer was dispatched to 970 Mansell Road. That's the Walmart there located at that location. Upon arrival to the area, the officers located the defendant who had concealed consumable goods on his person and crossed all points of sale inside the Walmart and outside the Walmart without attempting to pay for the goods. The officers detained the defendant and escorted him back to the Walmart loss prevention officer, who positively identified the defendant as the shoplifter. The defendant had previously shoplifted from this particular Walmart multiple times and has already been trespassed from the store. The defendant was subsequently arrested and the stolen goods were valued at $120. You've heard the criminal history and the amount of theft, Your Honor. The state's going to ask for $1,500 surety for the theft by shoplifting and a $500 surety for the criminal trespass, a stay away from the incident location, and no alcohol, drugs, or weapons while out on bond.
Thank you, Ms. Tucker.
Mr. Blocker is 63 years of age. He's been in the Atlanta area for 3 years. He does have family that resides in the area. He's currently staying at a recovery center on Trinity Street, 169 Trinity Street. He is not employed because he is disabled. He does have a FTA that's over 2 years. From over 2 years ago that he did receive while incarcerated. So we are requesting a signature bond if possible, because he wouldn't be able to afford a surety bond due to not being employed. He does not have any objections to not returning to the incident location. Again, we are requesting a signature bond, if not the lowest possible surety bond on his behalf. Thank you.
Right, defendant is going to receive a $20 cash bond, $10 on each count. He's to absolutely stay away from that location, have no alcohol, no drugs, no weapons. Is there anything additional? All right, best of luck to you, sir. Who do we have next?
Position 6, Mr. D.
Mr. Deeds, your case number is 25CR003192C. In this case, you're charged with false report of a crime. Do you understand your rights? All right. Please proceed, Mr. Howard.
33 on probation for entering auto out of car, identity theft, fraud, theft by receiving. 2024 FTA probation. 2022 theft by receiving, fleeing an officer. Okay, that's the probation. 2020 simple battery, 2020 probation, 2020 obstruction conviction, and a 2019 reckless conduct, possession of a firearm by convicted felon conviction.
Thank you, Ms. Falk.
Yes, Your Honor. This happened June 5th of 2025. Officers were called out to 1124 Wiley Street. The defendant told the officers that he left his gray 2004 Infiniti at that address for a mechanic named Rico to fix on June 4th. The defendant then stated he got a call on the 5th that his car was not at that location. The officer got the name and the picture of the defendant, which he found out matched the name and picture from a call that had gone out on June 4th, 2025, the day before the defendant reported his car stolen. On June 4th of 2025, officers actually made contact with the defendant's car, an Infiniti G35 bearing a New York license plate, which had been stolen out of DeKalb County. Officers observed the occupants of the vehicle and tried to stop the vehicle, but they exited the Infiniti and fled on foot. Affixed to the Infiniti was a stolen New York license plate held onto the vehicle with 2 rubber bands. Underneath the stolen license plate was the Infiniti's real license plate, which came back to the defendant, who the officer identified as one of the individuals in the car who fled when they tried to stop the vehicle. The Infiniti was involved in an entering auto of DeMarcus Richards' white Nissan Sentra, which was broken into and from which his black book bag containing laptop, cables, keys, and his Grady badge was stolen from. Mr. Richards identified his bag, which was recovered pursuant to a search warrant and was located inside of the Infiniti that was pulled over. Officers indicated in our report and our warrant that they're going to be taking out additional felony warrants, most likely for entering auto. I will state that the defendant's history is very in line with this offense. He has the 2024 FTA. He has a 2023 conviction for entering auto, ID theft, and theft by receiving out of Cobb, for which he's still on probation. He has a 2015 conviction for entering auto, 4 counts under 15 CR 2733. That's out of DeKalb County. He has a 2014 conviction for criminal attempt entering auto and possession of tools for the commission of a crime, and a conviction in 2014 and 2013 in Fulton County for, guess what, entering auto. So what we have is a pattern of behavior leading up to this incident, and quite frankly, the false report of a crime is just the beginning of the warrants that the officers are taking out. We tried to transfer this to the DA's office with the understanding they'll be taking out felony warrants. They said it in their report and in the warrants, and the DA's office told us to hold on until the felony warrants are taken out. So in the meantime, we are asking for a $2,000 cash bond, now alcohol, drugs, or weapons, and that's all for the state.
All right, thank you, Ms. Falk. Ms. Tucker?
Yes, Mr. Dees is a 32-year-old Atlanta native. He's completed education up to the 11th grade. He is not currently employed, so he would not be able to afford a $2,000 cash bond or any cash bond. So we would be requesting the lowest possible surety bond on his behalf.
Defendant's going to receive a $3,500 surety bond, and he's having alcohol, drugs, weapons. Is there anything additional from state or defense? All right, best of
None
luck.
from the state. Thank you.
Best of luck to you, Mr. Dees. Who do we have next?
Good afternoon, Judge. I have position number 1, Ms. Bailey. And can you please read that right?
Yes, ma'am. Thank you. Good afternoon. All defendants at ACDC, good afternoon. My name is Judge Melanie Williams. Today I am conducting this calendar by video. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to counsel today. When I ask if you understand your rights, I'm asking if you understand what I've just explained and how I'm conducting the hearing. Ms. Bailey, your case is 25 CR 0031884A. In this case, you're charged with loitering and prowling and criminal trespass. Do you understand your rights today? All right, thank you, Mr. Howard.
Fourth arrest, 2022 public order crime, intoxication conviction, 2022 shoplifting conviction, 2021 possession of marijuana conviction, resident of Pensacola, Florida, I think.
Okay, thank you. Ms. Falk?
Yes, Your Honor. This happened on May 24th, 2025 at 590 Mean Street, which is where the Carriage Works is located. The officer spoke with Sherman Hightower, who advised that the defendant was homeless and sitting in a black Nissan Altima. Mr. Hightower advised the officers that she was walking up and down Marietta Street, started pulling on the door handles of the Carriage Works, and then opened the door of the black Nissan Altima belonging to Raskiwi Adisa and sat in the car. Officers then made contact with her. She stated, "This is my uncle's car." There is a $10,000 surety bond currently set. We are agreeing to reduce that to a $1,000 surety bond, $500 per count. No further contact with Mr. Adisa. Stay away from 590 Mean Street in Atlanta. The Carriage Works, no alcohol, drugs, or weapons. We are recommending a social worker visit or MHET. This case originally was in municipal court. She had a first appearance on the 25th, and then this case had to be reset multiple times. The officer appointed her court attorney, initially assigned some special conditions, and she was still in custody when the citation was dismissed and the warrants were taken out. This is not a Riverside issue, as she did go before first appearance the day after the offense occurred in municipal court. So that's all for the state.
Thank you, Ms. Falk. Ms. Tucker?
Yes, Miss Bailey is 25 years of age. She has not been in the Atlanta area long. However, she is a mother to a 6-year-old child who she is the primary caregiver for. She is currently not employed. So we are asking for a signature bond on her behalf. She does have a limited criminal history, and I don't see any prior failure to appears on her history. So it is appropriate to request a signature bond on her behalf in this instance.
And Your Honor, I just want to sound for Mr. Adisa and also state that the recommendation was due to the lack of community ties and the fact that we're concerned we won't be able to find her for court.
All right, is Mr. Adisa present? Even though this is a loitering, will still sound. All right, defendant is going to receive $1,000 surety bond, 500 on each count. She's to have no contact with Mr. Adisa and stay away from the Carriage Works location. She's additionally to have no alcohol, no drugs, no weapons, and she is going to all purpose on the 19th. All right, best of luck to you, ma'am. That concludes your case. Who do we have next?
Position 16, Mr. Rucker.
All right, Mr. Rucker, your case is 25 CR 00319. I'm sorry, 00319. I'm sorry, why can't I read this? 00319-5H. Forgive me. In this case, you're charged with 2 counts of battery family violence. Do you understand your rights?
Yes, ma'am.
All right, thank you, Mr. Howard.
Second, 2024 theft by receiving DUR.
Okay, thank you, Mr. Sirocco.
Thank you, Judge. This incident took place June 5th, 2025 at 8350 Roswell Road in Sandy Springs. It's an apartment complex. Law enforcement responded to a domestic violence call. Upon arrival, the officer made contact with the victim, in this case, Ms. Tasia Walker, who explained the defendant, her boyfriend, they lived together, became enraged and attacked her after she hid his firearm during an argument about apartment keys. The defendant grabbed the victim around the collar of her shirt, pushed and pulled her, causing pain, struck her several times in the body with a closed fist, bit her on the left side of her lower jaw, and pushed her into the bedroom wall. He admitted that the two tussled, was vague in his details, and when asked about the cut on his hand, he stated, "I punched a picture." The officer observed the victim's t-shirt collar was stretched out and torn. There was a bite mark on her lower left jaw, a scratch on her forehead, multiple scratches with fresh blood on the back of her neck, and a trail of blood leading from the bathroom to the living room. She identified the defendant as her boyfriend, who attacked her. The defendant was arrested, and we've spoken with the victim in this case. The two are in a relationship. They live together at the incident location and share no children. She explained that they were in an argument about the mailbox key, and since the defendant would not tell her where the key was, she moved his gun. She stated that they began to argue. The defendant snatched her phone out of her hand and stated they continued to argue, and that's when the defendant grabbed her by her collar and began attacking her. She explained to us that this is not the first time that the defendant's been violent towards her, but it is the first time that the police have been called. She explained that she wants no contact with the defendant, wants him to stay away from the residence. We could not agree more. I don't believe, is on the line, but we would nonetheless ask the court sound for her when appropriate. With this not being the first time the defendant's been violent towards her, and given the severity of the attacks here, the state is asking for, given the risk of reoffense, a $4,000 total surety, $2,000 for each count of battery family violence, for him to complete FFIB, have no further contact with Ms. Tasia Walker, stay away from the apartment complex at 8350 Roswell Road in Sandy Springs, surrender any and all firearms to the sheriff's office, and have no drugs, weapons, or alcohol while on bond.
All right, I'm sounding for Ms. Walker at this time. Hearing none, Mr. McLean.
Your Honor, address in Austell, I believe, live with. So stay away, no problem, objection. We would ask for, establishes education, Your Honor, is some college and some HVAC training as well. He works at UPS, so that's logistics. So like I said, he can live elsewhere, and he'd ask the court to consider a lower signature bond, or if that is not possible, then a lower surety bond than the state mentioned. He would ask the court to consider 1,000 surety if a signature bond is not in the works. Thank you.
Thank you. Defendant's gonna receive a $4,000 signature bond at level 1, 2,000 on each count. He is to have no contact with the alleged victim, stay away from that location. He's also going to take the 1-day anger awareness course. He's to have no alcohol, drugs, nor weapons, and he will be reached at further notice. Best of luck to you, sir. Who do we have next?
Position number 2, Barbara.
All right, this is Ashanti Barbara, correct? Barbara, okay, your case is 25 CR 003185A. You're charged with criminal trespass and damage to property. Do you understand your rights today? All right, first arrest, so we'll go to Ms. Falk.
Yes, Your Honor. This happened June 3rd, 2024 at 10:20 p.m. at 2040 Stanton Road, which is the Stanton View Apartments. Emile Barber, the sister of the defendant, and Tony Jarrett, who is the defendant's 75-year-old grandmother, were at home when the defendant kicked the door to the residence. Officers observed that the door was damaged and the damage amount was approximately $200. Ms. Jarrett, who's the grandmother, advised that this isn't the first time the defendant has done this to the front door, and that she is fearful of being harmed because she sleeps on the couch next to the front door where this occurred. We did have an opportunity to speak with the caregiver of Ms. Jarrett, who is Tracy Thompson, who is also the mother of the defendant. She stated the defendant does not live at the incident location, that Ms. Thompson was at work when the defendant came to the residence and she told her not to. And she showed up anyway, trying to fight her other daughter, Miss Emile Barber. She stated that the defendant kicked the door and left. They got someone to repair the door. Then the defendant returned 30 minutes later and kicked the door in again. She stated that they do not want the defendant to return to the residence, and they want to have no contact between the defendant and Tracy Thompson, Tony Jarrett, and Emile Barber. I will say she stated she's unable to attend the Zoom, but I would like to sound for Tracy Thompson. We are asking for a signature bond through pretrial services, no further contact with the people listed, Tracy Thompson, Tony Jarrett, Emile Barber. Stay away from the Stanton View Apartments at 2040 Stanton Road. 2 days anger awareness, no alcohol, drugs, or weapons. That's all for the state.
All right, I'll sound for Ms. Thompson if she's present. All right, Mr. McLean.
This one's actually mine, Your
I'm
Honor.
sorry. My apologies, Ms. Tucker.
Oh,
Please
it's fine.
proceed.
Ms. Barber is 22 years of age. She's an Atlanta native. She's completed up to 10th grade in education. She resided at the incident location, 2040 Staten Road, for over 7 years. As the state mentioned, Ms. Tracy Thompson, her mother, is the leaseholder at that location. She, at the time of the incident, was, I believe, recently kicked out of her mother's home, but she did reside at the location at that time. She does not have any criminal history, and of course, no prior failure to appear. So we are also asking for a signature bond. In this case, we have no objections to not returning to the incident location, as well as no communication with the alleged victims in this case.
Thank you. Defendant's gonna receive a $3,000 signature bond at level 1 through pretrial services. She's had no contact with any of the alleged victims in this case. She is to stay away from that location, have no alcohol, no drugs, no weapons, and she will be reset for the notice. Is there anything additional?
No, Your Honor.
All right. Best of luck to you. That concludes your case. What do we have next?
Position 10.
All right, Ms. Harris, your case is 25 CR 00319 You're charged with obstruction and trespass. Do you understand your rights today? Is that a yes?
Yes.
Thank you. Say it loudly if you can. Thank you. Mr. Nixon, please. Oh, I'm sorry, Mr. Howard. This is not first. Go ahead.
This number 10.
Yes.
This is fifth arrest. 2024 controlled substance. 2023 forgery and a fourth obstruction conviction. 2022 FTA. 2020 robbery. It was amended to theft by taking conviction.
All right. Thank you, Mr. Nixon.
Yes, Your Honor. This occurred on June 5th, 2025. Officer Ruffin responded to a criminal trespass call at 325 Auburn Point Drive, apartment 6308 in Fulton County. The officer saw camera footage of the defendant and others being captured in the unit. And entering the unit, and officers met with the leasing office manager prior to approaching the door to assist in opening the unit. And actually, this unit is 6306. That unit was supposed to be vacant. As they approached the door, officer knocked a few times, announced his presence, and asked if whoever was inside to come out. After multiple times of knocking, the maintenance manager attempted to try multiple keys to gain entry. Shortly thereafter, one occupant that was later identified as the defendant shut the door, and the officer was notified by maintenance that two people are jumping off the balcony trying to leave from the back. The defendant was later detained. The defendant was also detained and later released on a diversion program, I think April 12, 2025, for a criminal trespass as well. Because of these facts and the FTA from 2022, along with the criminal history, the state is going to request a $500 surety for the obstruction, $500 surety for the criminal trespass, and a stay away from 325 Auburn Point Drive, Southeast. No alcohol, drugs, or weapons while out on bond.
Thank you, Mr. Nixon. Ms. Tucker?
Yes, Mr. Harris is a 26-year-old Atlanta native. He did complete his high school education. He is currently not employed, so it would be difficult for him to afford a surety bond. We do recognize that he does have a failure to appear. It is over 2 years ago. So if possible, we are requesting a signature bond. If not possible, the lowest surety bond that the court will allow. No objections to not returning to the incident location.
All right. The defendant is going to receive $1,000 surety bond, 500 on each count. He's to stay away from that location, have no alcohol, no drugs or weapons, and he is going to the all-purpose calendar on June the 19th. Is there anything additional? All right. Best of luck to you, sir. Who do we have next?
You got position 17, Judge, Mr. Singleton.
All right, Mr. Singleton, your case is 25 CR 003197E. You're charged with theft by shoplifting. Do you understand your rights? Oh,
Hang on.
okay. He's coming. Do you understand your rights today, sir? Is that a yes? All right, Mr. Howard.
This is ninth arrest. 2025 probation. He had a capital offense from 2022 that ended in a mistrial. Got a 03 carjacking conviction. I don't recall seeing any theft.
Okay, thank you. Mrs. Sirocco.
Yes, thank you. This incident took place June 4th, 2025 at 3660 Marketplace Boulevard in East Point. It's the target at that location. Law enforcement responded to a theft by shoplifting call. Upon arrival, the officer made contact with loss prevention employee Zenobia Drakeford, who had detained the defendant in the office and explained that she saw the defendant via surveillance camera select clothing in the men's department, enter the fitting room, wearing black t-shirt, black and white shorts, change then into the selected merchandise, and then conceal additional items in his backpack. He exited the fitting room in different clothing, now wearing a gray long sleeve, other various items that weren't the same, passed all points of sale without paying for various clothing items totaling $497.89, so just below the felony threshold here. All merchandise was recovered, and loss prevention identified the defendant through direct observation video surveillance here. It's placed under arrest. The state is asking for a signature bond through pretrial services, anti-theft course, stay away from the target at 3660 Marketplace Boulevard in East Point, and no drugs, weapons, or alcohol while out on bond.
Okay. Okay. Mr. McLean?
No objection, Your Honor. Good local address, bill that could mail, and phone numbers and relatives. Thank you.
All right, defendant is going to receive a $2,000 signature bond through the jail. He is to stay away from that location, have no alcohol, drugs, or weapons. Is there anything additional?
None from the state judge.
All right, best of luck to you, sir.
Position 15 next, Judge, Mr. Price.
Mr. Price, your case is 25 CR 003188H. You're charged with simple battery family violence. You understand your rights? Or where is Mr. Price?
He's coming, Judge.
Okay. You understand your rights, Mr. Price?
Think about it.
Was that a yes?
Yes, ma'am.
All right, thank you. Mr. Howard?
29. On probation out of the cab. Got ag assault, terrorist threats, cruel to the children, another ag assault. Got an open shoplifting in state court. 2 FTAs from 2020, simple battery DV, 2019 fade to appear.
Thank
Got an
you.
18.
That's good. That's good. Thank you. Mrs. Sirocco?
Thank you, Judge. This incident took place on February 11th, 2025 at 767 Mercer Street, Southeast Atlanta. It's an apartment complex. Law enforcement responded to a fight in progress call. Upon arrival, the officer made contact with the victim in this case, Miss Bianca Kelly, that's Kelley, who explained that the defendant, her boyfriend of 7 years, lives with her, had pushed her during an argument. The defendant pushed the victim, causing her to fall into a table, and she ultimately picked up a knife in self-defense because of this. The defendant grabbed her daughter's iPhone from the nightstand and fled the apartment just afterward. She told officers she did not want to press charges and wanted the defendant just to receive mental health help, but she did raise a knife in self-defense. She identified the defendant through a photograph shown by the officer, and a warrant was issued for his arrest. As you've heard, numerous violent convictions here. They go even further. There's ag assaults stemming all the way back from 2007. Battery family violence from 2013, as pretrial mentioned. 2 counts of aggravated assault, terroristic threats and acts, cruelty to children in the third. That's 2024, that conviction. And that case, she's the same victim here. The court ordered that the defendant would have 1 year confinement. This was the sentencing, probation for 4 years, and that the defendant would receive intensive MH treatment, provide proof of compliance with that, and be supervised by MH probation officer. But in addition to that, he was to have no contact, no further violent contact even, no contact whatsoever with Bianca Kelly, and was to complete a domestic violence intervention program. He has a foreign county hold out of DeKalb. It looks like it's for this violation of his probation. But additionally, there's a series of simple battery family violences stemming back from 2016. That one was his mother. I believe that case was Noel Pross. There was a 2017 for which I don't have the disposition, but that was another woman. He received a $5,000 surety bond for that. A simple battery, that was a simple battery, and a simple battery family violence in 2018. That was Noel Prost. That was another intimate partner violence, but against a different woman who was the mother of his child with whom he was living. There was yet another simple battery family violence arrest from 2020. That case was transferred to the DAs. I don't see a disposition for that on Odyssey, but that's another intimate partner violence against a different victim, a different mother of a different child, for which he received a $2,000 surety bond. FTAs from 2019, 2 from 2023. We have spoken with the victim here, Judge. They are now married as of March 7th and live together at the incident location. She confirmed the events on the warrant, but stated that the defendant suffers from MH issues, and was off of his medication at the time of the incident. She stated the defendant is now on his medication and things are good, and have been living together since without issue. She states she's not in fear and wants to continue contact, but we are absolutely not okay with that. She will be on Zoom, so we would ask the court sound for her when appropriate. Despite what the victim is asking for here, she felt threatened enough for her own safety in this situation to grab a knife. It is a simple battery family violence. It is a consistent marker in a pattern of violence that we're seeing from his history here. She knows, and we know what he's capable of here. We're incredibly concerned for her safety, and there is a significant chance of reoffense here. He's in violation of his probation from DeKalb, and he is a threat to her. What's more, none of the bonds he's received for any of these cases have put a stop to the violence. The probation hasn't put a stop to the violence either. And if he's done any of that FFIP, if he has, that hasn't helped either, because we're here again. Neither is MHET, by the way, and we're seeing some insight into that. Given this, the state is asking for a $5,000 cash bond for him to complete FFIP, comply with any existing recommended medication or treatment, have no further contact with Bianca Kelly, stay away from the apartment complex located at 767 Mercer Street, that's in Atlanta, and to have no drugs, weapons, or alcohol while out on bond.
All right, I'm sounding for Ms. Kelly. Ms. Kelly, if your president wishes to make a statement, this is your opportunity. Hearing none, Mr. McLean.
Your Honor, Price, since this is February 11th and considering the charge, I understand the points the state is making. But Your Honor, if signature bond is possible, we'd ask for that and a $1,000 surety bond. If it is not possible to do a surety bond, because as stated, there's been no problem since February 11th on that. Now, he is a high school graduate who does stalking in a retail situation, and prior to that did landscaping. So we would ask the court to consider that. Thank you.
All right, defendant is going to receive a $4,000 surety bond. He's to have no contact with the alleged victim, stay away from that location, have no alcohol, no drugs, no weapons, and he will be reset to all purpose on June 19th. Is there anything additional?
None from the state, Judge.
All right, best of luck to you, sir. Who do we have next?
Position 19, Mr. Tarver.
All right, Mr. Tarver, your case is 25 CR 003201E. You're tried with battery and simple battery. You understand your rights?
Second arrest, 2010, it was a driving offense.
Okay, thank you. Mrs. Sirocco?
Thank you, Judge. This incident took place May 25th, 2025 at 187 Edgewood Avenue, Southeast Atlanta. The law enforcement responded to a fight call. On arrival, the officer made contact with the victim, in this case, Ms. Daphne Smalls, who explained the defendant, who is an acquaintance of hers and lives there at the location. It's the Edgewood Support Services, had confronted her about money issues related to a previous drug transaction and net spend card incident. While the victim was standing outside the Subway restaurant with a witness, the defendant approached and said, "People are coming after me about the money, and it's not fair. Are you going to pay these people back?" When she refused to discuss it, he said, "Oh, you think you a bad bitch," and then proceeded to pepper spray her in the face and the eyes twice. The defendant admitted that he used the pepper spray on her because she would not resolve the issue regarding the drug transaction and net spend card. And after being Mirandized, he confessed that he approached the victim to confront her about paying individuals for drugs. And when she would not agree to resolve the issues, he pepper sprayed her. She was consequently unable to see. Her eyes were burning and swollen with pain after being sprayed. Both the victim and a witness, Mr. Millard Cosby, who have known the defendant for over 2 years now, helped identify him. A warrant was issued for the defendant's arrest. We have spoken with the victim. They were acquaintances, and she confirmed they do live at the same complex, the same apartment complex. That was the incident location. She lives in one apartment and he lives in another, and confirmed the events in the warrant. She says nothing like this has happened before him, and that she hasn't spoken with him since the incident here. She's insists to us that she wants no contact whatsoever, and she should be on the line. So if we could sound for her when appropriate. State is asking for a signature bond through pretrial services, a 12-week anger management course, no further contact with Daphne Smalls, stay away from 187 Edgewood Avenue, Southeast Atlanta, and no drugs, weapons, or alcohol while on bond.
All right, Ms. Smalls, I see you on Zoom. If you want to make a brief statement, please turn on your camera, raise your right hand.
Can you hear me?
Yes, I need to see you, and you need to raise your right hand.
Yes, ma'am.
Okay, and I'm going to give you some instructions. Please turn your camera on.
Okay, hold on. I've never done this. It says start my video.
All right, raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
Yes, ma'am.
All right. Before you start speaking, I'm going to give you some instructions. I'm most concerned with your concerns for your safety and whether you wish to have contact with the defendant here. The facts of the case are not important at this juncture. Defendant is entitled to a bond today. I'm most concerned about, your desires for contact with him. There will be other proceedings where we can get into what happened, okay? In light of those instructions, what would you like to tell?
We live in the same building, so we're gonna be running into each other. So, I can't say he has to stay away. We live in the same building. But as for how it affected me, we go outside and we smoke, and my comfort zone was just taken away because he could have appeared and attacked me again at any moment. I'm not comfortable opening up my door because I don't know what he's gonna do now.
For a long time. He ain't gonna bother with her. He never trouble before.
I want him to go to jail.
All right. I appreciate you coming to court making that statement, Ms. Smalls. Thank you.
Thank you. Thank
All
you.
right. All right, Mr. McLean, any objection to this signature bond, to stay away from her particular unit and no contact?
No objection.
All right. Defendant is gonna receive a $2,000 signature bond at level 1 through pretrial services. He's gonna take the 1-day anger awareness course. He's to have absolutely no contact with Ms. Smalls. If he sees her, he should turn around and go in the other direction. He's not contact her phone, text, maintain at least 1,000 yards from her. Additionally, he's to have no alcohol, no drugs, no weapons, and he will be reset for the notice. Is there anything additional?
Nothing.
All right, best of luck to you, sir. That concludes your case.
Judge, that's a 2K SOB?
Yes, 1,000 each charge.
I got position 21, Mr. Williamson.
All right, Mr. Williamson, your case is 25 CR 0031667E. You're charged with pedestrian crossing between a intersection improperly and giving false information. Do you understand your rights? All right, Mr. Howard.
Second, 2021 marijuana and possession of a controlled substance. Wanted out of Jasper County.
All right, thank you, Mrs. Sirocco.
Thank you, Judge. This incident took place June 4th, 2025 at Mansell Road, the intersection of Mansell Road and Kingswood Place in Alpharetta. This was a reset from yesterday. Law enforcement observed the defendant, a heavyset black male wearing a green hoodie, walking across the grass median, provided and working crosswalks at the West Side Way and Kingswood Place. The officer initiated a traffic stop, activating emergency lights, and identified himself and the reason for the stop being the crossing outside of the sidewalk. Upon asking for information or identification, the defendant stated he did not have any with him, but claimed to have a Georgia driver's license and had lived in Georgia for 11 years. He identified himself in his own handwriting as Chris Johnson with a date of birth of September 4th, 1990 on the officer's notepad. Multiple databases searches returned no valid information for that provided name and date of birth. Another officer arrived with a rapid ID scanner, and that scan returned a positive ID for the defendant with an active warrant from Jasper County, which, as it appears, is a failure to appear, dated back from April 11th of 2023. He was placed under arrest at that time. Given the open FTA, the state is asking for $1,000 total surety, $500 surety for each count. No drugs, weapons, or alcohol while out on bond.
All right, Mr. McLean. You're muted.
Sorry, Your Honor. Thank you. Been in Georgia about 11 years, college 2 years, Your Honor, in film and television, Associate of Arts degree. Works as a cook at a restaurant and also simultaneously has a second job as a night audit clerk at a hotel. Before that, he worked at one of our colleges here in Atlanta as a dishwasher in their student dining hall. Your Honor, if he is not legally ineligible for a signature bond, we would ask for a signature bond because this is just his second arrest. But if he's ineligible, then the $1,000 surety bond the state proposed is the best position he could be in. Thank you.
Okay, hold on. Let me look up one thing. Okay, defendant is going to receive a $20 cash bond, $10 on each count. He's to have no alcohol, drugs, weapons, and will be reset to the all-purpose calendar because of the cash bond on the 19th. Is there anything additional?
Nothing additional.
All right, best of luck to you, sir. Who do we have next?
I got position. Go ahead. I got position 14, Mr. Pittman.
All right, Mr. Pittman. Your case is 25 CR 003202C. You're charged with obstruction and loitering and prowling. Do you understand your rights today?
I don't.
You do? Okay. Miss, you said you do not?
Clean.
You have a right to remain silent. You have a right to an attorney, and I'm conducting this by video. All right?
11 on probation for shoplifting, not a decab. Fulton County got a shoplifting obstruction. 24 SC 003488. 2024 failure to appear. 2024 trespass, simple battery.
All right. Thank you, Mr. Nixon.
Yes, Your Honor. This occurred on June 4th, 2025. The defendant was detained for waving a knife while at the business of Lowe's at 3625 North Commerce Drive. That's in East Point. The defendant refused to place his hands behind his back by tight clenching his arms toward his armpits. The defendant then had to be physically forced to the ground, where he continued to not listen to lawful commands to stop resisting and place his hands behind his back. Your Honor, you heard the criminal history, including the 2025 theft by shoplifting felony. He's on probation for 3 years. The state is going to ask for $500 surety for the obstruction, $1,000 surety for the loiter, and a stay away from 3625 North Commerce Drive, as well as no alcohol, drugs, or weapons while out on bond.
All right. Mr. McLean.
Thank you, Your Honor. He's 22. I saw the obstruction charge. The loitering charge, I'm scratching my head on that one. Your Honor, we would ask the court, he is a cook and a clerk at a entertainment venue. So he both does cash register work, and he also fixes non-alcoholic drinks for the families that go to this entertainment venue. He, like I said, he's 22. I've got his address in Alpharetta. I've got his dad's phone number. I left a message, but I'm not sure the dad got it to be able to watch Zoom. Those were anonymous calls. I believe they would have been anonymous, claiming that he was waving the pocket knife. So we would ask the court to consider a signature bond. Thank you.
All right, defendant is going to receive $1,000 surety bond, $500 on each count. He's away from that location, have no alcohol, no drugs, no weapons, and he is being reset to all purpose on the 19th. Best of luck to you, Mr. Pittman. Who do we have next?
Got position 19, Mr. Evans.
Sorry, that position, it was at Evans?
19, Judge. Position Evans.
Joshua Evans?
That's correct, Judge.
Okay, I have that at 7. All right, Mr. Evans, your case is 25 CR 003193C. You're charged with battery and simple battery. Do you understand your rights today?
Yes.
All right. Mr. Howard?
25. You got open drug case, loitering problem. Try to sum this up. On probation for shoplifting, on probation for ag assault, 4 counts. It's 22 SC 1811506. He has probation holds and FS charges, so ain't gonna work.
Okay. Ms. Falk?
Yes, Your Honor. This incident happened April 23rd, 2025 at 11:30 a.m. Mr. Daniel Jarrett went to the Zone 5 precinct. He stated that on April 10th, 2025, he was going to pick up his ex-boyfriend, the defendant, from the Whole Foods on 14th Street. When he arrived, the defendant was acting irate, so Mr. Jarrett decided to leave. The defendant then threw an unknown object on the hood of Mr. Jarrett's car, which left 3 dents and a small hole in the hood. The defendant then opened the driver's side door of Mr. Jarrett's vehicle and struck him 4 times in the face with a closed fist. Mr. Jarrett stated he called 911 and waited, but after a long amount of time without help, he left. He did show officers pictures of his injuries and damage to the car. The officer did observe the defendant had a swollen lip and small lacerations to his lip and a bruise to his right cheek. The victim and the defendant are no longer in a relationship, according to Mr. Jarrett. They have never lived together. Mr. Jarrett did confirm the events in the police report. He stated his jaw is slightly dislocated due to this incident, and the way when he closes his mouth, his bite is not the same, and he is in some pain. He also stated this is not the first time the defendant has been violent towards him and not the first time police have been involved, but it is the first time there's been an arrest. He stated he does not want contact with the defendant since he has not had contact with the defendant since this incident and does not wish to have contact. He is asking for a stay away from his residence. I will put that in the chat for the clerk. And that residence is in Atlanta, Georgia. Mr. Jarrett also stated he will be here on Zoom and we will sound for him. The defendant is currently being held on 25 PI 004461 for possession of Schedule II, possession of drug objects, obstruction of a law enforcement officer, and 2 counts of possession of a firearm. As of today, that was in no bond status, but I believe he went to first appearance on those charges in felony court today. He also has a probation violation warrant on 22 SC 182721 that also has no bond status. The defendant has FTAs in 2016, 4 FTAs in 2018, a probation violation in 2019, 3 probation violations in 2024, and 1 in 2025. Along with the theft by shoplifting convictions, the state's main concern is that aggravated assault, first offender probation under 22 SC 181506. There is I believe, an arrest warrant for him for probation violation on that case as well, but it does not look like that has been served at this time. He also has the open 23 CR 006890 case for loitering and prowling and use of drug objects, where he has a $2,000 signature bond through the jail. And the other theft by shoplifting, which is in possession of a Schedule II case, which is open, and that is 24 PI 009329. In the aggravated assault case that is still open, just to let the court know, that incident involved the defendant burning 2 different people with a lit blowtorch and pointing it at 2 other people. So a total of 4 people were involved in that aggravated assault case. We are asking for a $10,000 surety bond. We feel there is sufficient evidence that there is a history of violence here, a risk of reoffense, a definite risk of not appearing to court. He had 4 FTAs in 2018 alone, 5 total. The breakdown would be 7.5 for the battery and 2,500 for the simple battery. We are requesting FBIP, no alcohol, drugs, or weapons, specifically no firearms, and stay away from the address belonging to Mr. Daniel Jarrett, as well as no further contact with Mr. Daniel Jarrett. At this time, we would like to sound for Daniel Jarrett, and that's all for the state.
Okay. Is Mr. Jarrett present? Okay. Mr. McLean?
Mr. Evans is.
I'm sorry. My apologies, Ms. Tucker. I keep seeing the cameras on and get confused. Ms. Tucker, please proceed.
Mr. Evans is a 35-year-old Atlanta native with a 10th grade education. He is currently not employed. We are requesting a $1,000 surety bond for each count. We have no objections to most of the state's recommendations. There has been a 3-month cooling down period since the incident. It occurred in April. According to Mr. Evans, he and the alleged victim have been communicating regularly, almost on a day-to-day basis, according to Mr. Evans. So we were asking for to allow for them to continue to have contact, but no violent contact. But we are requesting for a $1,000 surety. Thank you.
All right, defendant is going to receive a $5,000 surety, $3,000 on count 1, $2,000 on count 2. He's to have no contact with the alleged victim. Stay away from that location that Ms. Falk will put in the chat. Have no alcohol, drugs, weapons, and will be reset to the all-purpose calendar on the 19th. Is there anything additional?
Your Honor, you said no further contact?
Yes,
Okay, and can you give the breakdown again, please? My apologies.
three on count one, two on count two.
Okay, thank you, Your Honor. Nothing further from the state.
All right, best of luck to you, sir. Who do we have next?
Judge, I have a Mr. Demetric Williams. He was on our poor sheet, but he's not on the calendar.
Is this, anyone have, was that case NOD? I don't have it on the calendar and I don't have an add-on.
I
Not
did
to
it.
my knowledge.
What's the name?
Demetric Williams.
Matrix.
We don't have a Demetrius. We have a Leandre, but not a Demetrius.
Yeah, it ends in a CK. It's Demetric.
What's the book number?
His book number is, where'd it go?
0219. Yeah, it's a DUI, less safe, reckless driving, hit and run, and following too closely. Looks like a cash bond was issued on that, and it does not show that he has made that bond. Actually, I take that back. This is a bench warrant. Courtroom 2, this is a bench warrant case. He's an FTA. I can give you the case number right now. It's an FTA on 20 CR 003404F. This needs to go to SAP.
How much is the bond?
The bond is a $4,000 cash bond, but it's an FTA. It's an SAP case. It's not a first appearance case.
He does have some good factors where maybe the state might want to deal with the bond.
The state is not arguing a bond that they have not been notified on and that is being done at a first appearance hearing when this is not an SAP calendar. I apologize, PD McLean, I understand, but there is a process. And so we are asking this be reset to the SAP calendar as every case with an FTA would be.
Right. Can we get him on a SAP ASAP?
Yes, I will definitely reach out to Mr. Jordan, Ms. PD McLean, and let him know to put him on the next available SAP calendar. It will likely be on June 12th, since that calendar has not come out yet. I'm sure they can fit him on there.
That helps him. Thank you.
Thank you.
All right, so we won't be addressing that case today. Are there other positions at courtroom 2?
Yes, Judge. I have a Mr. Nasheed Harper.
Number 9.
Okay. Okay, let's see. Okay, Mr. Harper, your case is 25 CR 003191G. You're charged with loitering and prowling and criminal trespass. You understand your rights today?
Yes,
All right, Mr. Howard.
Okay, so he been arrested in 11 states. And I didn't count the total number of arrests, but I put in the notes for you. It's a lot.
Okay. All right, Mr. Nixon.
Yes, Your Honor, this incident occurred on June 6, 2025. The officer was dispatched to 3002 Gardner Drive in Alpharetta. When the officer arrived on scene, he was advised by the reporting party, Mrs. Victoria Barley, that a resident at the apartment unit across the hall from Unit 3002 had witnessed a suspicious male tamper with the lock and enter the vacant unit across the hall from his apartment unit. The resident notified the leasing office property manager, then sent an employee to the unit to attempt to check on the unit for any suspicious activity. The employee attempted to make entry to the unit by using the master key, but he realized that the privacy lock was locked from the inside of the apartment. And the employee stopped what he was doing and reported the incidents to his property manager. She proceeded to then call the Alpharetta Police Department. When officers arrived on the scene, they confirmed that the privacy lock had been locked from the inside of the apartment, which led them to believe that someone was still inside. And after making multiple attempts to call into the apartment and after banging on the door, the officers forced entry. The defendant was taken into custody. I believe the defendant is homeless, was eating food in the vacant apartment. I do want to point out with regard to the considerable amount of criminal history, I believe he has a 2016 trespass, in Missouri, 2017 trespass, in Missouri as well. 2016, 2017 criminal trespass in Tennessee, criminal trespass in Texas, as well as Florida, as well as a 2021 criminal trespass here in Georgia with a 30-day confinement. Your Honor, the state is going to ask for a $1,000 surety for the loiter, $1,000 surety for the criminal trespass, a total of $2,000 surety. And stay away from 3002 Gardner Drive, Alpharetta. No alcohol, drugs, or weapons while out on bond, and a social worker visit to address any housing needs.
Where is his, Ms. Tucker, where does he currently reside now? Do you know?
So he did tell me that he is homeless, currently,
Okay.
and so we were requesting a social worker visit as well.
Okay. I'm sorry, but go ahead with your argument if you wanted to address anything additional.
Yes, so Mr. Harper is 32 years of age. He's been back in the Atlanta area for the last 8 months. He is currently working. He's started working through a temp service and doing a factory job. He's attempting to get back on his feet while trying to gain residence in the area. He wouldn't be able to afford a surety bond since he's just starting through the temp service. And so we are requesting a signature bond if possible, if not the lowest surety bond that the court will allow for today. Thank you,
Your Honor, I'm sorry, Your Honor, we did note a 2021 FTA as well.
Okay. Okay, defendant's gonna receive $1,000 surety bond, 500 on each count. He's to stay away from that location, have no alcohol, no drugs, no weapons. I'm gonna ask that a social worker visit, but I won't require that as part of the order. He will be reset to the state all purpose on the 19th. Best of luck.
$1,000 surety bond, Judge?
Yes, 500 each count.
That's all I have in court, room 2.
All right, I know we need to go into the breakout for position 20. Was there an announcement on position 11? Sharon Harris?
Bond paid, Judge.
I'll bond it out. Thank you. All right, can we go into a breakout, please?
Your Honor, before we do that, courtroom 2, have we addressed Shockley? I got a call from the jail that they needed a modification of the bond order that Judge Morrow had issued yesterday.
They took care of that yesterday. She's at ACDC.
Okay. Judge Williams, just to make sure that we're all on the same page, Ms. Shockley was here yesterday. She was issued a bond by Judge Morrow. However, Mr. McLean pointed out that he believed, because Ms. Shockley pointed out that she believed she had paid her bond at East Point Jail, but before she could be released, she was transferred here. Judge Morrow said, well, if that's the case, can you present me with something that shows you paid that bond previously? PD McLean was able to get that over to us. I sent that over to the jail, but then I got a call from the jail about 15 minutes before I headed into court, letting me know that they were going to bring Ms. Shockley to court for Your Honor to address because they need to modify Judge Morrow's existing bond to show that she is already paid a bond previous to.
Did they let her out? Is that what they're saying?
They're saying they can't let her out until she comes before court, is what they said to me when they called me 15 minutes before court. So I'll go back and double check and see if they released her on it. But
that's what I was gonna say. Did somebody change their mind? She's gone now?
Well, she's got 3. Got Habersham, Cobb, and
she does have 3 FTAs. I will say.
Was she released to a hold? Is that what happened? I don't know. Okay, we can maybe someone can take a look at that, and let's do that breakdown in the meantime. Thank you, Ms. Falk, for bringing that to our attention.
Yes, Your Honor.
Judge, who's going in the breakout?
Mr. McLean requested it. Ms. Falk, I'm sure. Ms. Tucker and Mr. Sirocco are welcome.
Yes, please include me. Thank you.
It is Mr. Sirocco's bond.
Ms. Tucker, would you like to go in the breakout room?
Yes, you can add me.
social worker on Zoom with us today?
I saw Kasha earlier.
I talked to her.
I think
I
she's
let her,
gone.
I let Miss Simon Williams know this was coming up.
Okay, let's go into breakout then.
I'm here, Your Honor.
Oh, you're in courtroom too. Hi. Can we,
There she is.
are you by yourself?
I'm with the deputies. There's not.
Okay, there's no
Not
inmates.
here.
Okay.
No.
Can we put courtroom 2 in the breakout too then? All right, it appears that we have completed the entire SEA calendar. Ms. Champion, are you able to review it for me, please? Thank you. I like your hair.
So, position number one is a total of a $1,000 good bond reset SAP 619. Position number two is a $3,000 pre-trial bond reset for the notice. Position number three is a total of a $20 cash bond reset SAP 619. Position number four is a total of a $4,000 pre-trial bond reset for the notice. Position number five is a total of $1,010 split bond reset SAP 619. Position number six is a $3,500 good bond reset SAP 619. Position number seven is a total of $5,000 good bond reset SAP 619. Position number eight is a total of $1,500 good bond reset SAP 619. Position number nine is a total of $1,000 good bond reset SAP 619. Position number 10 is a $1,000 good bond total reset SAP. Position number 11 is reset for the notice defendant was released. Position number 12 is a $1,000 good bond reset SAP 619. Position number 13 is a total of $2,000 good bond reset SAP 619. Position number 14 is a total of $1,000 good bond reset SAP 619. Position number 15 is a $4,000 good bond reset SAP 619. Position number 16 is a total of $4,000 pre-trial bond reset for the notice. Position number 17 is a $2,000 sign-up bond to the jail reset for the notice. Position number 18 is a total of $2,000 good bond reset SAP 619. Position number 19 is a total of $2,000 pre-trial bond reset for the notice. Position number 20 will be reset to tomorrow's C calendar. Position 21 is a total of $20 cash bond reset SAP 619. Any questions?
Yes, on position number 4, was there anger awareness as part of the conditions?
I don't have it on my.
I don't think so. I don't
Okay,
remember.
I was just asking. I had the no further contact, stay away, one-time escort, and phone reporting.
Yes, I don't
Okay.
think I did that. All right.
Got it.
All right, we'll be in recess until tomorrow's SEA calendar. Take care, everyone. Have a good afternoon. See you all soon. Bye-bye.
Have a good day, Your Honor.
Have a good day.
Bye-bye.
Mr. McLean, can you tell me what the bond was on Darenice Price, please? You're muted.
I'm pretty sure it was 4,000 surety. I mean, I know it was 4,000 surety. I wrote that down. And I also wrote on NCSA. So I would think it was no contact, stay away.
No contact in the stay away order? Okay.
Ms. Kwong, what was you asking?
What was the bond for Mr. Darenice Price? Variance price, excuse me.
Variance.
You need the bond amount?
Yes, please, and the conditions.
Okay, hold it a second. $4,000 good bond, no further contact in the stairway.
Okay. Bianca's iPhone, were you able to hear that? And this is Mr. Price's wife, and she wanted just to know the bond recommendation and well, the bond order. Okay. That's all for me. Thank you, courtroom, too, and thank you, Miss Grace.
Thanks.
No problem.